Welcome to the Tinley Talks podcast, where we dive into the common legal issues facing today's community associations. Whether you're a manager, board member, or homeowner, you're sure to pick up on some nuggets of advice to help you build a successful community in this ever-evolving and changing world.
Welcome to Tinley Talk, the show that breaks down the legal issues affecting community associations. I'm Ramona Acosta.
And I'm Steve Tinley.
And today we're talking about AB 3182, rental restrictions, with Kumar Raja and Mark Dodge. Kumar is an attorney with Tinley Law Group in our Mission Viejo headquarters. He's assisted with the representation of several large master planned common interest developments throughout Los Angeles, Riverside, and Orange counties. During the scope of that representation, Kumar provided general counsel on a wide array of litigation and transactional matters. Mark is the president and CEO of Associate Desert Resort Management, the largest HOA management company in the Coachella Valley. His experience is wide and includes both senior management and financial positions in the publishing, sports marketing, automotive, technology, and event management industries. Thank you both for joining us today.
Thank you, gentlemen. Welcome.
So we're going to talk about AB 3182, which I think was the legislature's response to California's affordable housing and homelessness crisis. Public policy within the state has changed within the last couple of years to create more affordable housing in an effort to get the homeless off the street. I know, Kumar, you wrote a white paper on this recently. I know you did a little bit of research on this. Do you know what the impetus was behind this, why the legislature decided this was an issue with HOAs?
Ramona, you said it the best. There's a feeling that the HOA restrictions would prevent or limit the amount of housing units available to Californians. So the thought process is if we lifted the restrictions by way of California law, we could potentially open up the housing market to individuals that would normally not be exposed to that type of housing.
But why target HOAs? I mean, it seemed like the assembly member, who was it, Phil Ting, who wrote the legislation, it seemed like he had something specifically driven towards HOAs, like somehow homeowners associations in the state of California are just NIMBYs, not in my backyard. We're not going to have these low-income renters in our associations.
Well, the thought is that HOAs are becoming more and more of a commonplace housing product through California. So, in other words, they have much more power than perhaps they used to. So the thought process is that with lifting the private restrictions in that regard, we're again opening up the housing market.
So my understanding is that this piece of legislation would essentially render void and enforceable any provision within the governing documents that prohibit, has the effect of prohibiting, or unreasonably restricts the rental or leasing of a separate interest. And I'm so excited that we have two attorneys here because I need to understand what that means.
So, essentially what this means, and this is fascinating, right? Because you have homeowners associations that traditionally enjoyed authority to regulate themselves. We'll have neighbors in our community, they'll buy into our governing documents, we'll adopt the type of restrictions in order to effectuate the type of community that we want. So for our community, it doesn't work for us to have rentals of any kind in here. For whatever reason, whether it's assessment delinquencies or just the nature of the neighbors that we have here, let's not have rentals. And the trend of the legislature has been, okay, well, HOAs, that autonomy that you enjoyed before, it's slowly been curtailed. So what was it, 5 or 6 years ago when we had the Right to Rent Act, right? That was the legislature's first bite at the apple. And that was interesting because that was sponsored by the California Association of Realtors, and they were looking primarily for their buyers. They were concerned about speculators. They say, well, if somebody buys a home in a homeowners association with the intent to rent it out, but then the HOA starts prohibiting rentals, that's going to chill investment in these communities. Now taking that even further, what the legislature is doing is we don't even care about the housing purchases or the housing market itself. We have an affordable housing crisis, and we need to find a place to create more affordable housing in California. So what are we going to do? We're going to treat these private communities now as being regulated by us and allow them, or not allow them rather, to restrict rentals. So in doing that, what the legislature says is HOAs cannot prohibit or adopt a restriction that has the effect of prohibiting or unreasonably restricts the renting or leasing of a separate interest. What does that mean? What constitutes an unreasonable restriction? I think at this bite at the apple, the legislature has kind of defined that for us. They've defined through AB 3182 what they think a reasonable restriction is, and a reasonable restriction is a restriction on vacation rentals, short-term rentals, rental periods for less than 30 days. Before, Kumar, when we were drafting documents for clients, we would have other types of restrictions that we would put in, right? For example, some communities, they would want to adopt, well, if you want to rent out your unit, you have to have owned the unit or lived in the unit for at least a year in order to deter people just buying units in order to be able to do that. But that seems like that's no longer going to be allowed now under the state of AB 3182. Is that how you're reading it too?
Absolutely.
Right. That would be a reasonable restriction. Also a reasonable restriction, some homeowners associations would adopt caps on the number of rentals in their community. And they would do that because the concern that if they get 50 or 60% of the rentals or the units in the community rented, then the whole character of the community changes. So they said, well, listen, let's adopt a cap, a ban. Once 10% of the units in our community are rented, nobody else can rent their unit until there's a space that frees up, and there'd be waiting systems and things like that would be imposed. But it seems like now with AB 3182, a 10% rental cap isn't reasonable, and what they've done is they've set it at a 25% rental cap. So if an association now wants to ban rentals in excess of 10% of the community, it can't do that, right?
Absolutely.
So Mark, in your world in a management company and the associations that your managers are working with, are you seeing a lot of rental restrictions, maybe short-term rentals, but are you seeing just rental restrictions by and large in your governing documents?
No, I think principally because in the desert, so much of the build happened in the late 2000s, and a lot of that was speculative. So a lot of those restrictions don't exist in those documents from like the late 2000s. Because so much of that product was sold to investors. So in the desert, though, and in the desert, our situation might be different from some other places where our principal challenge out there is the short-term rentals. Mm-hmm. It is not the rental in general. It is an issue, but it's a secondary issue to the short-term rental issue.
Because one of the things that I've been noticing, and this legislation, it takes effect January 1st. But one of the pieces or one of the components of it is that associations have to amend their governing documents by December 31st of next year to remove any of these prohibitive rental restrictions. And what I've been grappling with in my mind is most of our governing documents don't come with rental restrictions other than that short-term rental provision of the less than 30 days. So any restrictions that are in the governing documents are restrictions that the homeowners already voted to put in. And so now we're going to ask the membership to now vote to take them back out?
Yeah, we have to. Well, that's what's interesting. So we had, what was it? It was SB 323 last year, right? The election rules. So we have two recent pieces of legislation, right, where the legislature has limited what an HOA's authority is, SB 323 pertaining to election rules. But not only did they do that, they said, oh, and by the way, we're issuing a mandate for all HOAs throughout the state to change their documents to conform to the requirements that we're putting in. So it's not as though that they're just putting these restrictions on us, they're actually issuing us an edict and a time frame by which we have to amend these documents. So by the end of 2021, every association that has rental restrictions that violate this new law, they have to amend their governing documents. So they're going to have to consult with their legal counsel to do that. So I guess, I don't know, maybe our firm should send the legislature a gift basket for creating a bunch of needless work for us. But it's definitely an interesting thing to see them to do that. The vacation rentals have been something that makes sense, and I think it's a fortunate thing that the legislature has kept that ability for HOAs to restrict short-term rentals. They consider that a reasonable restriction. We're going to be able to do that because those are the most disruptive. I remember I was working with a client in San Diego, and it was really funny. They said, we have a huge short-term rental problem. So, well, what are you experiencing? He said, I had a renter call me in the middle of the night trying to place an order for room service. Because the board president's information and said if you have questions or anything, something along those lines. That's how pervasive it was. So short-term rentals, those have been an issue. But I always thought it was an interesting thing because some communities that we work with, we don't want renters of any kind. We don't want renters in our community whatsoever. And there was a thought process was, well, if we have renters in here, the things are going to change and so on and so forth. in working clients, I haven't really experienced that. I mean, some, renters for the most part, right? Long-term renters that are there, they're neighbors, they're in their community. So in some respects, you kind of understand and you could agree with what the legislature is doing. So that's at least fortunate. Do you have any crazy rental issues that you've dealt with lately, rental restrictions?
No, it's more or less along the, the long-term renters, they feel a part of the community, so they're more likely to follow the rules. But it's the short-term renters that, in the desert communities feel as if it's a resort, where they can run roughshod. They tend to be less respectful of some of the common area assets. So, I've heard stories out in the desert where a short-term renter will take to the golf course and use the slopes as moguls, after a few beers in the evening. Or they'll take a ping pong set out to the green and play beer pong.
Yeah.
So that's the type of the conduct I think that the legislator is honing in on with respect to what is and what is not a reasonable restriction under this new law. The challenge with this new law is, as Steve indicated, there is some indication of what's reasonable, but there is an open in terms of what is unreasonable, and that goes back to what Steve said.
Right.
You're gonna need to talk to your legal counsel on a variety of issues related to this bill. What is and what is not reasonable? Can we leave our documents as is without amendment because it potentially does not violate the new law?
My initial, when this bill first came out, my initial response to it was actually not negative. It wasn't, because the combination of the two things, it kind of carved out the 30-day restriction, and it got people thinking about the percentages, because in a vast majority of our communities, almost all, I wouldn't gather, didn't have any sort of limit on the rentals in that regard. So now some of them are thinking about it and moving in that direction. This is one thing we can do. Maybe we should do this. Whether that's the right response or not, I know in most cases it's not. With the problem set that we are experiencing out there with the short term, everybody's looking to do anything they can that throwing out the wall and see if it'll stick and alleviate some of it.
Yeah, it's interesting that your initial response to it was a negative. I think so many people, professionals in our industry, they're kind of, because we're in an industry that's very dynamic, changes that the legislature adopts these bills every year. We have to draft these articles and advise our clients, and I think reflexively, a lot of the response from people in our industry is, there's a new law, this is a bad thing. This is a bad thing. For example, the balcony bill, we'll be talking on another episode about this. There's a lot of concern associated with that legislation, but as the substance of it, I think it's a good thing. This I could understand as well, and I think there's some merit to it. The concern that I have, and Kumar, you touched on it in your white paper, is the level of ambiguity that's there with regard to, what's unreasonable, what's reasonable. Going back to what we talked about earlier, the types of renter restrictions that we would typically enforce. One common thing is, if you want to rent out your unit, and you as a homeowner have the ability to do that, or you want to rent out your home, you have to rent the entire thing out, right? You have to have a lease that covers the entire property. So what was that intended to prevent? That was intended to prevent an owner subletting out individual rooms of the home to individual parties, right? In order to change that product type into, now it's more like a hostel, something to that effect. Based on AB 3182 and reading your white paper, you're saying that it's not even that clear, Kumar, as to whether or not that type of restriction would be something that would be reasonable, or even if a homeowner lives in the home and at the same time rents out one of their spare bedrooms, is that property considered rented, quote unquote, under the new law?
Probably not. The reason is, again, it goes back to the hosted rental or hostel situation. If an owner is occupying the property, is that really a rental? The way that this statute has come forth is almost a hodgepodge of definitions. So there's one aspect of the definition that carves out what is and what is not a separate interest. An ADU and a JADU is not considered to be a separate interest. If you were to unpack the language, I certainly drew the conclusion in the White Report that if the owner is anywhere present at the same time on the property, it would not be considered a rental for purposes of the short-term rental cap, and then also the rental cap prohibition.
Okay.
So for those that don't know what an ADU or a JADU is, could somebody explain that?
I'll try.
We're basically talking about the granny flats, or like in Coachella Valley, we're talking about the casitas. We're talking about either the garage conversions, turning those into a bedroom, or we're talking about, the homes on the wheels that you can roll into your backyard.
Yeah, little tiny homes.
Right? I mean, that's what we're talking about.
Yes,
Secondary
accessory
properties.
dwelling units is ADU and JADU, and this is another bite at the apple that the legislature, was it last year or the year before, we saw legislation that was passed that prohibited associations from banning ADUs. So if I own a home, a single-family home community, and in my backyard I want to create an accessory dwelling unit, right, that has its own kitchenette or something to that effect, called a granny flat or whatever, the legislature says, casita?
That's what they're called in the desert. They're casitas.
Casitas, okay. Casitas. We're going to have a casita in the backyard. Associations, 5 years ago, they could prohibit that, arguably, under their guidelines. Now that's not the case as of a year or two ago. And taking that further, now, in terms of this rental restriction legislation, the legislature's actually contemplated the fact that, well, wait a second, someone might want to build an ADU for the purposes of renting it out. And we cannot allow associations to prohibit that type of a rental, because what is that doing? It's defeating our legislative intent behind this, which is to create more doors, more housing, right? So how do we get housing more affordable in California? We'll take every piece of property and allow people to build little houses on them, and make sure that an association can't do anything to restrict the rental of that. So under this new AB 3182, the way that I read it and going through the white paper and how you analyzed it, Kumar, if a homeowner lives in the home, but then they have an ADU and they're renting out that ADU, is that property considered rented?
No.
It's not considered rented. It's not defined as rented.
Right.
But what if that homeowner is renting out that ADU for a vacation rental purpose?
Same.
It's not considered rented.
It's just, it doesn't really.
So it doesn't really solve the housing crisis.
No.
Because in a market like Mark's, where homeowners are finding ways to VRBO their properties, because you've got Coachella, you have so many festivals out there. Same thing with San Diego. With Comic-Con, you have homeowners who are finding ways to turn their property into an investment opportunity. This doesn't solve the housing crisis. This just creates more investment opportunities.
Yeah, it doesn't solve it at all. I mean, you have, in my opinion, the obvious economics, which is most of the places where you need housing units, they're just not conducive to creating low-dollar rental units, right? The place where you have the biggest need are not places where the real estate is cheap enough to create a rentable unit.
Right.
For somebody who is homeless or economically challenged or anything like that.
Yeah.
But to your point, though, I mean, more broadly, the Valley, I find it ironic that in the Valley we have kind of given up on controlling rentals through rental restrictions.
Interesting.
Does that make sense? Because you really, I mean, there's so many damn ways for somebody to frame a short-term rental in a community where the short-term rentals are prohibited, that instead, I mean, I have my managers try to focus on the manifestations, right? Focus on your parking issues. Focus on your noise issues, the things that you can control.
Yes.
Don't add layers to the onion and add all these other restrictions that you're not going to be able to effectively enforce anyways. I mean, it's a classic 80-20 rule, right? Where 80% of your renters, short-term or long-term, are good. 20% are not. And 80% of your problems come from that 20%.
Yes.
It doesn't matter what balance it is. So focus on controlling that 20 with things you already have there. Because, again, somebody that's really bound and determined to do that and bound to thumb their nose at you, you're going to be better off focusing on the other things anyways.
That's a really insightful and smart point, because we've experienced challenges. Well, we know this person's bringing out on a short-term basis. Well, how do you know that? Then they try to find screenshots of Airbnb listings, and they try to, and it's never really workable. And it's another example of when we talk to our clients that are concerned about things and they want to regulate things, it's always instructive for us to kind of take a step back and say, listen, our job is to regulate conduct, not things, right? A large pit bull, right, in itself is not a problem. An aggressive pit bull is a problem. So if and when this pit bull named Daisy or whatever that everybody loves becomes a problem, we'll deal with it on the basis of a nuisance restriction or something to that effect. But just having the idea of this dog in the community is not necessarily a bad thing. The idea of a renter in the community is not necessarily a bad thing. A problem renter is a bad thing. A problem landlord is a bad thing. So if and when there's conduct, whether it's parking or nuisance issues or so on and so forth, you're absolutely right. The best weapon that you can wield, right, the best arrow in your quiver is to deal with it on those grounds rather than trying to use the rental restriction in order to attack it.
It's an easier target in most cases, focusing on those things.
Yeah, absolutely.
Today's episode is brought to you by Altera Assessment Recovery. Altera provides comprehensive attorney-supervised assessment collection services to community associations throughout California. Trust us with your collection needs. We'll get the job done right, and as quickly and efficiently as possible. Altera Assessment Recovery. We're the collection team you've been looking for.
Well, and I think there's some unintended consequences to the legislation, and I know, Kumar and I kind of talked about it when he was writing the paper, because what about parking? When the associations were designed and when they were developed and they received their initial approval from the city, there's typically a required number of parking spaces that are associated with the number of residences in the community. Well, now we're adding ADUs, we're adding JADUs. We've got the prospect of more short-term rentals. There's more drivers on the streets. There's more people using the pools. There's more people using that entry gate. How does the association deal with the extra nuisances, the extra rule violations, the extra expenses to the wear and tear on the components that were supposed to have a useful life that may not have that useful life anymore because now they're being used more frequently?
Well, you can argue that in both directions, right? I mean, obviously, the infrastructure was built. The community I live in it's a good example. 65 homes, the infrastructure there's one pool was built to support 65 occupied homes. Now, so define that occupied homes. Is that typical valley pattern, which is 50% of the people aren't there for half the year, or is that 100% all year? And then the reality is that the way communities are built, at least in the valley, is they are not built for full occupancy. The gates are not built, the motors on the gates are not meant to withstand that volume of opens and closes. The gate arms, those sorts of things. There's a whole series of things that you could argue that the developers build, when they build a community, they build that sort of infrastructure for a predictable use pattern, a certain amount of wear and tear. I could make the argument that that's our standard. That's what we need to manage to, and that to your point, Ramona, is that any other use pattern beyond fully occupied 65 homes, 65 residents, whether they're full-time renters or whether they're owners like me, that's the way that community was built and intended to be used, which then precludes all of your short-term rentals from that use pattern. That's a hotel. That's something completely different.
Totally different animal.
Completely different animal. But I can argue the other side of it as well, which says, to the point I just made, 65 homes are meant to be occupied 100% of the time. And whether that's a short-term rental, long-term rental, resident, whatever it may be, that's what the infrastructure should have been built to. That's what it should be maintained to, and that's what we should be budgeting to.
Yeah. 65 households. So what's interesting, I'm even thinking about it right now with this ADU and the JADU stuff, these accessory dwelling units, and the legislature's trend towards this, right? Under the state of California law as it is now, in a community such as yours with a property such as yours, you have the right to build an ADU in your backyard, and you could also convert a portion of your existing residence to a JADU. You could have both. So a community such as yours that has 65 households has the potential to be, 195 if I'm doing the math right? Potential households if everybody decides, hey, we're going to do this. Maybe that's what the legislature wants. We can't afford housing here, so let's have everybody encourage them to start building tiny houses in their backyard and monetizing them. I just don't.
And the reality is that you're not going to get 195 doing that, but I think the 80-20 rule could and over time would apply. And I know that there was some legislation a few years ago that pertained to the extra costs that were associated with short-term rentals and whether or not associations could charge the landlord or charge the homeowner for the extra costs that are being associated to the association as a result of these short-term rentals.
Yes.
Can the association, and again, this is a broader big picture, but could that also be applied to these renters where you have the association is charging the homeowner an assessment rate based on this single family use, based on the formula that's in their governing documents. But now you have one homeowner who has a single family in their home versus another homeowner who has an ADU and a JADU. Can the argument made that this other homeowner should pay a little bit more because there's more use of the common area being used by this homeowner? Is that a reasonable restriction? Is that something that we could amend within our governing documents? Or does that have the effect of prohibiting the rental?
Yeah, it's a sensible question. So I think it was an appellate court case, right? The Watts case, Oak Shores, Watts versus Oak Shores. The fact pattern was it was a boating community, and there was a bunch of vacation rentals. And the common area facilities, the gates, the roads, the staff time, dealing with all of these short-term rentals and the wear and tear, this community, to its credit, if I remember the case correctly, they went through and they did a pretty exhaustive audit and financial analysis and projection in order to determine that, well, every time we have a short-term rental, it results in about this much expense on average for the community. So they started levying fees on homeowners, and it was upheld in the court. So taking that logic to this, that's a really interesting thing. Well, now we have so many more households in our community because of these ADUs or these JADUs, or even if they're just keeping the same residents, but because now we have more renters and there's more time associated with it and there's more burden on these things. Is it a reasonable restriction, do you think, in the legislature's perspective to say, okay, if you rent out your property, this is what we've done, and we can kind of pick that, hey, it's going to cost you, $500 a year for a rental license in the HOA. What do you think about something like that, Kumar? You think that would fly?
Yeah, the essence of that case was, is it reasonable, right? And so in that case, the board had done a lot of legwork to prove that the tax on the association's resources was justified by looking at the numbers. So I think if the board, in exercise of its prudent judgment in working with management and its financial professionals, can really draw a compelling argument, you could potentially make the claim to impose a fee on renters. But again, this law, as Ramona had mentioned, doesn't go into effect until January 1st, 2001. No court has evaluated what is and what is not an unreasonable restriction. Moving back to the critical necessity to work with legal counsel. Only your legal counsel will be able to tell you what is and what is not an unreasonable restriction.
So do you think that the rental administration fees might be perceived as a unreasonable restriction?
It could be, because what's happened here is the new law has expanded the breadth of what is prohibited now. Before it was prohibitions, now we have unreasonable restrictions and anything that could potentially cause or lead to an unreasonable restriction. So the playing field has changed, so to speak. So it's possible. It is possible that this could be an unreasonable limitation, because now there's now an extra fee that wouldn't normally be there.
But you're not prohibiting. I guess the answer though is that you're not really prohibiting a rental, or you're not effectuating a rental prohibition, because you're allowing the rental. There's going to be a fee associated with that. It's going to limit, I guess, the type of rental, right? Because any fees, I would imagine, if I'm a landlord and I'm renting out my ADU or my JADU, any fees that the association assesses as a result of that, I'm going to pass on to my renter, right? So
yeah, theoretically.
It goes back to that, whether or not it's affordable.
Affordable or not, yeah.
Based on reality, yeah. I mean, we have those rental administration fees. You got me nervous even mentioning that. We have those rental administration fees in a handful of communities now.
Yeah.
And we do it right. We support the expense with hard costs.
You support the expense, right?
And we do the mailing once a year, affirming the rule and say this is what it's going to be. We just do that, kick it out with our policy disclosure once a year. If we change it, we do it like a rule change and send it out for 28 and do that all right. And we send out the budget. This is what the fee is based upon, this expense load. And these are the additional expenses we believe are the result of the rental activity that we are administering for the community.
Got it.
As opposed to, so it's passing on those additional expenses to the people that are actually incurring the expense.
Yep.
Right.
Rather than charging people that don't use their property like that for those expenses that aren't even...
Yeah, they shouldn't have to subsidize somebody. I actually think the court, in that Watts case, they said the rest of the homeowners in the community should not be forced to subsidize the member who is the subject of the lawsuit, their vacation rental, business, which I thought was an interesting thing. The fees, so you're having some basis before you decide what the fee is, what the administrative fee is. You do some type of financial assessment, right? Some type of analysis in order to determine what that amount is. So
Your big expense out there in the desert is usually security, right? We're having to do additional patrol. We're having to do, one of the things that invariably happens, because of that 80-20-80 scenario I described before, is the management company ends up taking on some of what I would call the traditional property management responsibilities. Because you're the one doing the policing of the bad behavior. The property management company is normally a distinctly separate party. They have responsibility for the renting and the leasing and the maintenance, but they're not dealing with a lot of the bad things.
Got it.
Unless they're forced to.
Got it.
And so, you look at that activity, and again, we have one community, 500 homes without the ability to restrict rentals in their documents, and it was built in 2009, 2010. Right at the end, it was sold to a lot of investors, and 50% of the homes are owned by investors and rented out, and a lot of them are rented out short term. So, it was pretty easy in that scenario to put together. Okay, we have a need for additional security to deal with the manifestations and the parking issues and the noise issues, all this late night issues. So we started there. And then we added in, okay, we have to administer this in the office. What is the cost of keeping track of all this? What is the cost of access at the gates and getting people clickers and the gym access and those sorts of things? So there was an administrative expense on top of it. And you just keep stacking those on. Other properties are easier. We have another one where it is definitively easy. We have extra trash pickups on the busy holiday weekends. We have those sorts of things that are added in as well.
Got it. Well, that to me is something that if a client did and that type of work was done and it was administered that way, I wouldn't be concerned about it whatsoever. We'd be in compliance with, right, what's the code provision that says HOAs can levy a fee that exceeds the costs, right, that it needs, right, the money that it needs to defray that expense. What you've done is you've quantified what the expense is, so then that fee is lawful under existing law as well, probably under the reasonable standard of AB 3182. My concern is you're going to have some communities that are going to try to say, you know what, no, to rent in this community, you have to pay $5,000. So it's almost going to be a deterrent, right?
Yeah,
prohibitive.
Absolutely. That's where I was thinking. It's more of it's discouraging rental behavior when the whole law is policy towards encouraging more housing on an affordable basis.
The spirit of the law basically says thou shalt not put in unnecessary speed bumps, right?
Yeah.
And that big fee not based upon an actual cost. I can see how that would be questioned.
Definitely.
And that makes sense.
Right.
I'm hoping that isn't extended down into the situations I just described.
Yeah, so that's what the legislature is looking at here when it says a provision that prohibits or has the effect of prohibiting, right? So yeah, you adopted this ridiculous renter fee that has the effect of prohibiting rentals in your community because nobody wants to pay that amount of money or they can't pay that amount of money. But if it's a fee that's tied to costs that you incur, that your management firm has done the back, absolutely, I think that's something that we would be able to defend successfully if that was challenged for one of our clients.
Because I think something like that, I think this conversation would allay a lot of fears that associations might have. I don't think that by and large associations are opposed to rentals. I think as you said, Mark, it's the behavior that comes with it. And then again, it's the wear and tear on the infrastructure that wasn't designed to have the extra individuals in the community using all of those components. So if we can defray some of those costs, if we can manage some of that, if we're allowed to put some of those restrictions into our rules and regs, I think that alleviates a lot of the fears.
Definitely. Yes. Some boards might say this is going to present problems. We might have some challenges. They may not. But if they do, fortunately, there are avenues, existing avenues that we have in our documents to resolve those issues. It's not something that we can just stop at the door. Once it comes in, if there are challenges that are presented, we still have avenues to deal with them to make sure that your community isn't entirely burned by it. I'm really interested about this example, this community that you work with, Mark, that you said has this super high rental population and it's primarily vacation rentals. So a lot of the people, both sides of the argument, one of the biggest concerns is, well, if we have a high renter population, especially high vacation rentals, the whole community is going to be strained by this. Is that the experience in this community? Is it very disruptive?
It is.
It is.
It's very disruptive. The flip side of that also is that the property values are obscene and through the roof because of the ability to short-term rent in that market historically with the festivals.
Ooh, interesting.
Drove up property values. This year has been an interesting year because a lot of that lure with the festivals was taken away. The festivals in 2020, and the future may hold something different. But in 2020, that the valuation the property valuation effect was negated. But it was again midsummer or so where I would say that kind of flipped, meaning more people with hotels and all of the hospitality industry largely locked down. More people looked to those short-term rentals for those weekend getaways, and we had more activity in the summertime, late spring, summertime, and fall than we've ever had before.
Wow!
I mean, the desert in many places was a zoo this summer.
Was it?
Absolutely.
And that's usually when it's not that used because the climate out there it's the hotter part of the year. It's called off season, right? It's typically off season,
right.
But this year the off season was the on season.
Correct.
At least for renters.
Because you had everybody looking to get out of the cities and come out there. They're coming out there for the weekend. There was not enough hotel capacity, so the communities that had the short-term rentals were being used in the summer like never before.
Interesting. Well, one final point I want to ask you about, Kumar, is we saw it last year with SB 323, the election rules. And when that legislation was passed, I think a lot of people in our industry understood that associations were going to be compelled to amend their election rules, to amend their election operating rules. They had to do it, regardless of what type of community you had, regardless of where you were located throughout the state. It doesn't matter. Everybody, by virtue of the legislative requirements that were imposed and the mandate that was imposed, every association had to amend their election rules. Having a recent memory of that coming to this, I think a lot of people are going to be concerned, oh, here we go again. Now this is with rental rules. Do we have to, does every association, no matter what, as a result of this, have to do something to amend their documents?
In my opinion, not necessarily. It's going to be a case-by-case association governing document specific analysis. It really depends on what your documents state. Not all documents are created equally. You need legal counsel to tell you whether this particular governing document needs to be amended. Now, rental restrictions can appear in a variety of documents. They can appear in the CC&R as a recorded covenant, but it can also appear in an operating rule. If I've seen situations where the rental restriction appears in an operating rule, that's a much easier way to amend because you don't need to go to the members for approval. When you see a rental restriction in a CC&R, again, close scrutiny should be had because it looks like we're going to need to amend the documents with member
approval. So we're going to have to use ballots and envelopes and do that whole kit and caboodle. And what's crazy is that we're getting the membership's approval on something that we have to do anyway. So it seems like a silly exercise, doesn't it?
Right. In my opinion, I'm trying to do anything. I'm trying to think outside the box. I'm trying to think: is there any way we can comply with the law without soliciting member approval?
Like what you hear so far? Make sure to subscribe to the Tinley Talks podcast at tinleylaw.com and never miss an episode. This podcast is made possible by listeners like you. Thank you for your support. Now let's get back to the show.
Well, I think with short-term rentals, right, because we went over this as a firm, we kind of went through this over the last couple of years with associations that wanted to create short-term rental restrictions, and we went through this process of, well, do they really need to amend their CC&Rs, or can we do this through operating rules? Can we use the current language within the governing documents and clarify that through operating rules? And what I'm hearing from you, Kumar, is that it's really going to depend on the specific language within that association's governing documents to determine whether or not we can just do a clarification, or whether or not it's going to have to require member approval, or whether or not we even need to do anything at all.
Yes.
We might not need to, yeah.
You may not need to.
When this was first signed, I had a few clients ping me, and they said, we have to do this, and I looked through your documents and said, no, you don't. There's nothing in your documents that violates the law, you don't have to do this, and so on and so forth. And that was a really interesting moment for me. Those that do, though, and this is going to be the challenge, because with the election law change, when we had to amend we were able to set that up and do a large number for our clients and do it very cost effectively, because it was basically a template that we had to work from, right? The legislature told us this is what you have to adopt. But if a community has rental restrictions that violate this new law, It's not as though we're going to be able to just give them necessarily a template that they can use that's quick and cheap and gets the job done. It might take some more thorough analysis and going through it and parsing out what aspects of their documents need to be reviewed. And then we send it to the membership for their approval if it's a CC&R amendment. And we say, membership, we need your approval to do something that legally we're required to do, whether or not you like it. So, I mean, that to me is just fascinating. Do you know, Ramona, if there's any cleanup legislation proposed for this? I mean,
there is CAI's California Legislative Action Committee is working with the author to have an amendment next year. This was an 11th hour amendment. It was when it went to the other house, when it went to the state senate, that a senator went and put this language in. And my understanding is that the senator wanted it to go to membership approval because he wanted the members to be on notice that they could create these ADUs and JADUs.
Interesting.
And create affordable housing.
Why not just create a no? I mean, I would love to have that senator, he or she, sitting at this table and say, okay, you want us to solicit, we have to amend our CC&Rs to solicit, and in order to do that, we have to get our membership's approval. So we send it out and our membership doesn't approve.
Right.
What do we do? What do we do now?
And that is very, very feasible in the situation.
Yeah, no, we're not voting on this.
You get a bunch of owners that dig in and say, you know what, I have restrictions on my. Well, you don't have a choice.
Yeah.
You actually have to.
The catch-22.
Right.
Well, and that's my question because, I've been in this industry for a very long time. And most of the governing documents that I have seen that have rental restrictions, those rental restrictions are there because the members voted them in.
Yes.
So now you're going to ask those members to now vote them out. And that's where I think you run into the problem because either you have apathy and they don't vote at all, or they say, well, we wanted them. Why are we taking them out?
Yeah.
We voted to put these here.
I mean, it's a really sensible question for a member to go, if this is something legally that we have to do, otherwise we could be penalized, why do you need me to check a box that says yes, go do it? That's a little suspect, right?
It goes back to the situation a few years ago when the code was all rewritten. Now the number references were all changed.
Yeah.
And they let you just redo the documents and change the number.
Yes.
Because it was required.
Yes, and we were scratching our head because, with our websites, we dig through the code. I like to think we know it, chapter and verse. I said, is there something in there that gives the board the authority to amend the CC&Rs if needed to comply with a change in the law? And there is no direct language within the Davis-Sterling Act that says that. I actually have a couple communities, and it's a really smart idea. When they've restated their CC&Rs, they put a provision in there. It says the board can, by a vote, amend the CC&Rs solely to bring it in compliance with a legal requirement, and there's a notification requirement that has to go out. This is an active adult community in Riverside County, and I said, yes, you have to amend your documents, but thank goodness we get, because it's a large community, 2,000 homes. So just conducting that election in and of itself, what a wasted expense that is for something that they have to do. So in this community, the board just has to pass a resolution just like they would an operating rule and send it to them.
We need to send that over to Mr. Ting for that supplemental legislation, because you can accomplish the notification through just that, right? Where the board has the authority to make the move to comply with law on member notification.
And honestly, that was the big frustration because this literally happened, I want to say it was less than 2 weeks within the end of the legislative session. And so the Senate had to approve it so that it could get back to the Assembly, so that it could go through concurrence, so that it could pass in time before the end of the session, and then it could be sent to the governor's desk. So it was one of those things where it got slipped in at the last minute. There were no hearings, there was no public comment. And it went bam, 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 and went through. And then because there's an affordable housing crisis and because of state policy, it was approved and it was signed. And it's one of those things that now we get to go back and see if we can fix it.
Yep.
Well, and Steve, you mentioned the penalty, and I don't think that we got into that. Because a lot of the conversation that I'm hearing from some of the management companies and some of the other law firms is, well, if you don't comply, it's just a fine. It's just $1,000 fine. It's no big deal. Don't worry about it. We've got time. I mean, that's to my understanding. The language is that it's a civil penalty of up to $1,000 plus actual damages. And again, I'm thinking, okay, actual damages. What is that? Lost rents, attorney's fees. I mean, that could actually add up, couldn't it?
Well, it could, and actual damages. Yeah, I mean, there's nothing that can stop somebody from filing a lawsuit against the association. Kumar, we always have to tell our clients this when they say, "Well, if we do this, will we get sued?" Maybe. Well, so then we shouldn't do it then, because then we won't get sued. No, you still might get. I mean, you could always get sued.
Right.
You could always get sued, and
Right.
I can start seeing it right now. If someone's home sale falls through because this document was in there, and then all of a sudden they said, "Well, I lost this home sale because you didn't amend your documents, and that was my buyer, so my actual damages now." And they do this, and they file this, and now it gets tendered to the association's insurance carrier. There's some settlement that's paid out or something to that effect, and then the association's burdened by way of a loss history showing this thing. So I always. Our practice of law, our firm's approach, is always to tell the client what they need to hear and to follow the law. I think it's a very difficult thing for an attorney to say, yeah, that's what the law is, but if you don't follow it, it's not as though it's that big a deal, right? That's just ethically, that's a difficult thing to do, especially when you understand who our clients are. Our clients are corporations, right? They're not these board members. So when we have to tell them, for the best interest of our corporation, we have to tell you as the elected leadership of this corporation, you got to follow the law, right? Whether it's a $500 fine, you don't know what the damages are going to be, so on and so forth. That's what the law is, and we have to run with it.
To your point, Steve, I agree 100%. You've got to follow the black letter law. Now, the legislator did throw us a bone by including the word willful in the penalty provision. And the word willful it's a different term than negligence, which is conduct that falls below the standard of care. Willfulness is wanton or malicious conduct. So you, as board members, must really be in a position where you're sticking your head in the sand, where you're not reading the law, you're not consulting with the lawyers, and you're intentionally doing that. That is what exposes you to the $1,000 penalty and the damages. But if you do what you should do as prudent board members, in a volunteer capacity, ask your management team, ask your lawyers, you should be fine.
So let me ask you this, counselor.
Yes.
So you have a board member that comes to you and says, well, if we don't do this, we don't go through this whole expensive thing, right? What's it? It's a fine. It's fine. It's not that big of a deal, right? So we're just not going to pay attention to it. We're just going to pretend this thing doesn't exist. At that point, is that willful? Is that a willful violation of the code?
Well, it could be. I mean, it depends. Did the board member, did they read the law? Do they understand the consequence? Are they intentionally turning or moving the
Yeah.
Yeah,
But these are all these things. These arguments have to be made.
Right.
It has to be litigated, which means you're spending money on attorneys fighting over it, which means that what value are you adding to your community by leaving this skeleton in the closet, so to speak, that could rear its ugly head? I just don't think it's a smart governance approach. Especially for volunteers.
I think in our communities, anything that's conflicting, we will not participate in the enforcement of that come January 1st, right? That has to be your line in the sand.
Smart.
There's things that if you got conflicting things you've been doing, let's remove those now, because we don't need to be the case, the case law, right? And I think you're right. There's going to be some boards that are going to plow forward and keep trying, say, you know what, whatever. Certainly, but I think more often than not, that's what you might see, in my opinion, is you might see some people stop enforcement but not change their documents.
Not change their documents.
That's what I was thinking.
That's what I'm seeing as well. They're not going to enforce. They're not going to change their documents because they don't want to go through the expense of the double secret ballots and members not approving. And the law says that they shall be amended by December 31st. And so I guess it goes back to what Kumar's talking about, is whether or not it's willful and what the end results of not amending those documents are going to result in.
Well, willful, the flip side of that, in my opinion and in my brain, is that we, even if, again, the CC&Rs don't get amended, if we've got a blatant operating rule that's getting thrown into escrow disclosure packages that probably is interfering with sales or interfering with valuations or something like that, that would seem to me to feel pretty willful as well. Not only should we not be enforcing, but we should also not be trying to, in a clandestine sort of way, interject something that may interfere with somebody's vision of how they're going to be able to use the property by sending around documents that are not correct in the operating rules.
So, at a minimum, it just seems to me, just having been a manager for as long as I was, it just seems the easiest thing to do is just to recommend to the board that you have legal counsel review your documents and make a recommendation and start there. Because you're probably not going to have to do a whole lot to begin with unless you're a newer community or you actively put these restrictions in there. If you're a 1960s, 1970s, 1980s community and you're just running off of your original docs, you're probably not going to have to do much.
Yeah, but as a volunteer homeowner board member, you have to rely on the expert. So you have to reach out to legal counsel. What do we need to do? What should we do? And that's what I love about this conversation, like so many of our other educational articles and things that we do. It always comes to distill down to, at the end, you need to call your attorney, right? In this case, yeah, have a call. Those other clients, they always, this was a month or so ago, they had a committee formed for the purposes of evaluating this, so on and so forth, and then they called me, and within 10 minutes, I would say, you don't need to do anything about this, your docs are fine. So sometimes for those communities, simple call will have it, but the other communities where there are challenges and they need to go through and amend it for it, that's the value that we're here to provide.
It's going to be those communities that have gotten quote unquote cute in the past and baked too much specific detail into
Exactly.
CCNRs, where you got maybe even some conflicts in there that you guys are going to have to look at, fish through, and say, okay, yeah, we got to clean this up, or maybe, you know what, maybe we don't. Maybe because the rules over here, this is a mess to begin with. The rules over here, we're clarifying that to begin with, so maybe the rules just, yeah.
And correct me if I'm wrong, but the association has legal counsel review the documents. Legal counsel sends them a letter and says, you know what, everything is great. We don't see anything that needs to be corrected in order to comply with the law. And that home sale next year doesn't go through and they point to something in the documents. The board has some protection, right? Business judgment rule, the board is not protected because they went to legal counsel
Yes.
blessed it.
Yeah, it's a perfect example. I mean, the best that when we always, through our board leadership seminars, we tell these homeowner board members, if you're an attorney, you can't practice law for your association. That's not supposed to be your job. Or if you're an investment manager, right? Or if you're an engineer, so your job as a volunteer is to be a volunteer and to rely on the advice of third-party professionals that you bring in for your corporation, your HOA, and rely on them. And that's in this case, too. That's what's important. Do we have to do anything? Do we not have to do anything? That decision needs to be pitched to legal counsel so that a volunteer board member can say, regardless of what that decision is, I did my job as a fiduciary. We relied on the advice of the expert. I didn't take it upon myself to practice law and go through our documents and make the determination, no, we're okay, or no, we need to do this or that or the other thing. So, okay, so in summary, yes, so what have we learned today? You need to call your legal counsel. Right? That's the moral of the story. But one of the notes that I'm reading here, Ramona, that you put together is, and I think it's a really great one, don't panic. Most documents will not require amendment, but also don't panic, and this is to the point that you had at the beginning of the conversation. This legislation isn't terrible, right? There's avenues that are there. Yes, it needs to be cleaned up and refined a little bit, but the substance of it isn't bad. And if there's problems with renters in your community, we're going to still have avenues through our other restrictions or our nuisance clauses and so on and so forth to deal with those. So more renters isn't necessarily a bad thing in a community. Bad renters are a bad thing, and we'll still have the ability to deal with bad renters before AB 3182 and after AB 3182.
We didn't talk about whether it really is going to make more affordable housing or not, but
yeah, is it?
It's not. It's not.
It's not.
Right?
No.
Because it's based upon the assumption that there's all these units sitting around that people would like to rent out, that they're just sitting there waiting, holding on to those units, waiting to rent
Maybe
them.
the thought process is how we make housing more affordable is give homeowners the ability to monetize their existing units. So yes, I can afford to live in that community because I'm going to be able to derive rent revenue.
Right.
Maybe that's.
But I mean, you look at like the desert. I mean, everybody was nervous initially about the ADU, the junior ADU thing, but the reality is the way, again, especially a lot of the newer build. With the setbacks, there's no room in the backyards.
Yeah.
You can't. I mean, with restrictions on code and how you can convert the garages and the municipalities, you can't do anything with the garages. So the restrictions, the layers of restriction are still kind of there at the municipal level to doing a lot of those sorts of things. And then again with this, the assumption is, I think I like the argument that at the most this does is it has the opposite effect.
Yes.
Because you open up rental ability, drives in investors, drives up prices.
Yes.
It does in the desert. That's out there.
It's so funny how the solutions.
It's exactly the opposite effect. If it manifests itself like they intended,
yeah,
it's the exact opposite effect. It gets them the opposite.
It's the exact opposite. Yeah, our lips are chapped. Let's lick them.
Right.
It's just.
I mean, because you look at, the average. It's capitalism, right? I mean, and it's whack-a-mole. I mean, you get restrictions in one community, you squeeze it out, and these investors are smart. This isn't worth my time or money to be here. They sell. And they go find and buy somewhere else.
And they did, and they added the 25% cap to protect the FHA financing. But if you have a property with too many investors where you have one homeowner who owns several units, that also takes your FHA approval. So it's, yeah, they didn't solve anything.
I don't believe so. It's like most laws with HOAs.
Well, that's remarkable considering how effective and wise our legislature typically is in California.
One of the best.
One of the best. Mark, thanks so much for the time.
Oh, no
for
problem.
driving
Thanks for
out.
driving out.
I know,
Thanks
it's
for the
super
invite.
cool.
Awesome. Well, that's our show for today. Thank you all for listening. We'd like to thank Mark Dodge and Kumar Raja for your time and expertise today. Make sure you visit our website at tinleylaw.com if you haven't already, where we break down this episode and link to our blog article, California Legislature Further Limits at HOA's Right to Restrict Rentals. Then stay tuned for our next episode.
To share or subscribe to the Tinley Talks podcast, visit us at tinleylaw.com. There you can find links to everything discussed in this episode, locate helpful resources, check out other episodes, and submit questions for future topics. And be sure to tune in next month for our next episode. As always, the views and opinions expressed by the podcast, its presenters and guests do not constitute legal advice. For more information on the topics discussed in today's podcast, please consult with your association's legal counsel. This is Tinley Talks, presented by Tinley Law Group. Your community, your counsel.